Welcome to Planning for Protection.
Welcome to Planning for Protection with attorney Jeff Ryder. Jeff is an elder law and estate planning attorney serving families across Carroll County and the surrounding Indiana communities. I'm Evan Mack, and today we're talking about how Medicaid eligibility actually works and the common mistakes that can cause families unnecessary stress. Welcome, Jeff.
Hello. Well, good to be with you.
Good to see you. Jeff, a lot of people aren't sure where to begin with Medicaid. When someone comes to you for the first time, what do you look at to help them understand their options?
Well, normally I sit down with usually a family or a person, and if they tell me a little bit about their situation, what their loved one's health is like, where they're at, whether they're in a nursing home, in an assisted living facility, in a hospital, or getting ready to transition to one of those places. And so then I got a mental list of questions that I ask, and it basically involves, who are you? What's your details and your data, date of birth, social security number, all those kinds of things, address. And then we go into, who's your family? Who are the people that might expect something from your estate when you die? And we talk about children, stepchildren sometimes, nieces, nephews if they don't have children, or charities. So there's a million options, of course, whatever people have in mind. And then we go into their assets. And I try to ask all the major categories of assets. And then I say, is there anything else we should have talked about we haven't talked about? And the reason for that is Medicaid is very, very, very concerned about two things: assets and income. And so the asset piece of it is what we have to begin to explore fully to make sure we know every asset, because Medicaid uses an asset verification system that is getting surprisingly good at finding assets. And if we don't report an asset and they find one, it's egg on our face, number one, and delays eligibility, number two. And, if it's intentional, it could be even worse. So we don't want to omit any asset. Then we talk about income, and that, of course, is Social Security, usually pension, maybe rent from a property, and all those things we start to organize and get into a manageable data set on a spreadsheet that we can utilize expeditiously.
So what do Indiana's rules consider when determining their eligibility for Medicaid?
Oh, man. I joke that Medicaid has got a million rules, and they all interrelate to a degree, and you really have to know them. And if you don't, you can make some serious mistakes, which is why people consult with elder law attorneys such as myself. The rules are, I guess one big thing is, have you made any transfers in the last 5 years? And if so, were they more than a total of $1,200 per year? And if they are, then you have made transfers that trigger a penalty period of ineligibility for Medicaid. And so, small Christmas gifts aren't a problem, but gifts to, a kid of a car, or other cash gifts, or other gifts of any kind, really, need to be fully explored and detailed. And there are some remedial things we can do, but it takes some planning, and that's why people come talk to attorneys.
The 5-year, look back is one of the most confusing parts of Medicaid. What should families know about how that works?
Oh, man. The idea is, if you are going to the nursing home, you might say, oh, I know, I'll just give all my property away to my family, and then I'll apply for Medicaid and be approved. Well, no, it doesn't work that way. And if it did work that way, then obviously everyone would just do that, and the Medicaid rules would expand dramatically. So the state of Indiana and the federal government have said any transfers that you've made within a 5-year period prior to applying for Medicaid for a nursing home setting are going to be transfers that produce a penalty of ineligibility. And that penalty period is 5 years from the date of the transfer. So if you're going to be doing any transfers, you got to be very careful about it, and you got to keep very good records, and you need to think maybe once or twice, maybe 2 or 3 times about doing it because of that potential for those transfer penalties.
So Jeff, what are some of the most common mistakes you see families make when they try to handle Medicaid planning on their own without somebody like you?
Oh man, it's difficult enough to process a Medicaid case when you know what you're doing and know all the rules. And I can't imagine. Here's the distinction. I think if somebody has got very few assets, like a couple $1,000s in the bank, and no property, no house, for certainly no house, then they can apply for Medicaid and usually be approved without too much drama or delay. However, if you've got any resources, or if you're married and you have a spouse, all those situations cry out for some guidance because there are so many rules. And a few of the big rules are you've got to be below the resource limit, which is $3,000 for a married couple and $2,000 for a single individual. And if you're one penny over those resources on the first moment of the first day of each calendar month, then you are over-resourced and not eligible for Medicaid. So it's a very rule-driven and rule-intensive field, and you really need to have the guidance of someone who knows those rules to be able to navigate them successfully.
Mm. And early planning can make a huge difference, Jeff. What tends to change when families start to prepare before that crisis hits?
Well, that's a very good question, Evan. One of the things that has become a significant part of my practice is asset protection planning. And that's planning that you do at least 5 years before an event or need comes up. And as people transition into their 70s or 80s, suddenly all the possibility of a need like that becomes more real and more imminent in terms of the timing. And so it's not too early, if you're in your 60s, especially maybe 70s, it is not too early to begin to think about, what would happen if me and or my spouse would end up needing to go into long-term care. And the cost is so significant now that, it's in our area, it's not unusual at all to see $10,000-$12,000 per month per person, for nursing home care. So it can deplete your resources very quickly if you haven't done any planning. So one of the key things that we utilize are asset protection trusts, which are irrevocable trusts and still have grantor status. And so they are able to shield your assets both from the eligibility determination at the nursing home entry level, as well as estate recovery, which is what happens when a person dies. Are their assets going to be subject to needing to be sold to pay off the loan that Medicaid has made to the family and wants to be reimbursed for when the person passes? So 5-year planning is a very big consideration and something I do quite a lot of.
Well, so Jeff, could you share a story or example that shows how maybe that misunderstanding about eligibility created maybe something that you could avoid, like avoided problems in the family?
Man, there's so many. There's probably a million examples like that. One of the most recent ones was I had a situation where the wife had been in the nursing home and had been approved for Medicaid, and then her husband's health declined, and he needed to go to the nursing home as well. And despite my best explanations, the son had a misunderstanding on the target eligibility date, and he thought I said each of them could have $3,000. But no, it's not that way. That's a total of $3,000 for the both of them. And so that delayed eligibility for a month because, we needed to bend down that extra $1,000, which wasn't hard, but of course it had to be done. So that was a misunderstanding, and we try very hard to avoid those misunderstandings. We explain things over and over till hopefully people track and get at least a decent understanding of what they're doing and why they're doing it. Because I don't want anybody to say, well, I did this because Jeff told me to do it. I want them to understand why they're doing it and why it's important and what the issue is if they don't do it. So we try to educate people as best as possible to understand these rules, at least as it applies to their family's particular situation.
Awesome. And Jeff, for someone beginning to plan, what are the most important documents or financial details they should gather before meeting with an elder law attorney like yourself?
Well, that's a very good question, Evan. Basically details about their assets and details about their income. And I tell them everything, every fact needs to be established in writing with a piece of paper from the company or the entity that is generating the document. And we usually need a date as well, showing what date it was generated at. And so all those things become very critically important. And there are just many of the things people need to know. And we give them a detailed list of all the documents they need to gather, things like their birth certificate, their marriage certificate, Social Security cards, or Social Security numbers, their Medicare information, their Medicare supplement information, million details. But we guide people and walk them through that process of gathering all that data.
Awesome. Jeff, thank you so much for your time.
You're very welcome, Evan. It's been a pleasure with you.
That's it for today's episode with Planning for Protection. If you'd like to learn more about attorney Jeffrey Ryder and his work at Jeffrey C. Ryder Attorney at Law, LLC, visit jryderlaw.com. Thanks for listening, and remember to leave a review, and subscribe to the show so you do not miss the next episode. Thank you so much, and we'll see you next time.
Thank you, and have a good day. See you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.